Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is William Mahan, who's an attorney. I'm going to call him Bill. And Bill has his law office in San Jose, California, here in Silicon Valley. He's been practicing law for 31 years, has a master's in taxation degree, he has a master's of letters in law from Golden Gate University, and also a Juris Doctor degree from Santa Clara University. His practice focuses on estate planning and probate and business planning. So, Bill, thank you for coming and being my guest today.
My pleasure.
Okay. So today, Bill and I are going to be talking about tax and financial considerations of title. And before we get started, I'm going to caution our viewers to seek legal advice. What we're talking about involves, of course, legal concepts and so forth, so you really should see your own lawyer related to your own situation. It's just to be an introduction and a way to start a conversation, we hope. And also, I want to alert you that we're talking about California law. We have people who watch this program on the internet from other areas in the country and so forth. So the laws do vary a little bit from state to state and country to country, certainly. So anyway, so just be aware of that. Okay, Bill, well, let's get into some of our questions here. What are some alternative forms of holding title to property?
Well, let me start by saying that there are different kinds of assets that you can title.
Mm-hmm.
Real estate is a really typical thing people think about, but
Sure.
also bank accounts, brokerage accounts, even your car
Mm-hmm.
or your boat, you have title documents. And so there are different ways of holding title to these things. The common ways would be, if it's just yours, it would be your separate property. If you're married, you might hold title as community property. The types of title that you see on deeds and things like that would be tenants in common.
Mm-hmm.
That usually means people have what's called an undivided interest in the property, so they're tenants in common with an undivided interest. There also is joint tenancy with right of survivorship, which is a very common way that people use, whether they're married or if they're a parent and child trying to avoid probate and avoid doing estate planning by
Mm-hmm.
titling assets that way. For married people and for registered domestic partners in California, we have title by community property, and a fairly new version of that would be community property with right of survivorship, which is a combination of community
Mm-hmm.
property and joint tenancy, sort of. And then also, people often owned property inside of other things, like a trust.
Mm-hmm.
So a simple type of a titling would be a bank account that's held as a custodial account
Mm-hmm.
for a minor child, or something like a in trust for account, payable on death account.
Uh-huh.
And then people will set up entities like partnerships, limited liability companies, even corporations, or trusts, and they'll transfer title of property to those entities,
Mm-hmm.
For different reasons, but it's possible to hold title to the property in the name of an entity as well.
Okay. So, how do people try to bypass probate using the title?
Right, I touched on that a bit already, but
Mm-hmm.
the main way would be joint tenancy.
Mm-hmm.
What joint tenancy with right of survivorship means is that you've got a group of people who jointly own a property, but it has a special kind of an element to it, which is if a person dies, then the surviving joint tenants become the owners of that interest. So if you have 3 joint tenants and one dies, you now have 3 equal owners as joint tenants. And so because of the right of survivorship provision, the property doesn't have to go through court, through
Mm-hmm.
probate court when a person dies. And so it's sort of what's called sometimes the poor person's or the poor man's estate plan, because you don't have to have a will or a trust to leave assets to people. It just passes through title without any kind of probate administration.
Mm-hmm.
And then we also have this community property with right of survivorship, which is another way to do it for married people or registered domestic partners. So those are fairly common things people will do. I'll get a lot of phone calls from people who are talking and saying, well, can I do that? Doesn't that work just as well as, for example, doing an estate plan? There are many reasons why I don't think it's a good idea.
Mhm.
Lots of reasons. And I think we'll talk about that in a minute.
Mhm. Okay. And then I guess the other thing you mentioned, the entrust for account, so like the Totten Trust.
Yeah,
is
yeah. The
another
payable
one.
on death accounts, the trust accounts, that has the same kind of effect. You can be the owner while you're alive, for example, in a payable on death account, but it's payable to another person at your death. So anything that has sort of a beneficiary designation to it, whether it's a retirement account or an annuity,
Mhm.
these are things that will pass to other people when a person dies because of the beneficiary designation.
Okay. Now, um, what do you think is the biggest mistake that people tend to make relating to title?
There really are a lot of mistakes, and
Okay.
some of them can be a whopper.
Mhm.
But I think the most common one is the one we've been talking about, which is where people think that that's a good way to pass title on after they die.
Which, the joint tenancy is?
Joint tenancy is the
okay.
most, I mean, the others are in marital situations and things like that, and there are ways of dealing with, in the case of divorce or whatever, where you deal with doing that. But with joint tenancy with right of survivorship, the problems are manifest in that oftentimes people don't die in the right order.
Yeah.
And so people think they've done planning,
Mhm.
but because they die in the wrong order, the parent or the grandparent ends up being the surviving joint tenant and nothing really happened. Except that now things may be more complicated because it may not be possible to undo it or to fix it, depending on what kind of condition the surviving joint tenant is in. And the other problems with that are things like when you put other people on the title to your property, it seems like a simple thing to do, but in reality, you've done a very complicated thing because if they go out and have a traffic accident and there's a judgment against them that's in excess of any insurance that they have,
Mhm.
well, one of the assets that they have their name on title to is your property, might be your home.
Mhm.
So that's a problem. And also, people get divorced, comes up at that point. So you don't want your house in your son's divorce. And then sometimes you put people on title to your property and then you have a disagreement. Some of the most difficult cases I've seen in my career have been exactly those kind of cases where people started out together and then they decided they weren't going to stay together, not necessarily married people, but just family members.
Mm.
And then they have a parting of the ways and they have a really complicated legal problem because they're joint tenants or co-owners on property.
Okay. So how can a husband or a wife accidentally transmute separate property to community property, and what are the consequences? And maybe you should explain what that means.
Right. Well, again, it depends on the kind of asset you're talking about. It's sort of difficult, I guess not impossible, but difficult to accidentally transmute title to real estate, for example, because usually you have to do some kind of a recorded document. But for other things like bank accounts, a transmutation from community to separate or from separate to community occurs when somebody, let's say you start out with separate property coming into a marriage, and then do something to make it community property. Now, you might do something intentional, like a written agreement or a gift or something like that, where you add somebody's title to something. But you also can do it accidentally, particularly with things like bank accounts and investment accounts, simply by letting any community property be added to an account that was separate property. So, for example, if you get a paycheck after you're married and you deposit it into an account that was your separate property account, unless you have a prenuptial agreement that says that paycheck is separate property, it's deemed to be, under California law at least, community property. And as soon as you put in that first paycheck, you've tainted that account, and that's transmuted that account to community property from separate property. So you need to be thoughtful and careful with particularly financial assets after you are married and they become community property, what you do with them if you want to maintain separate property.
And what I found is most people aren't so thoughtful and careful.
Yeah, especially over the course of time, because they don't really think of it that way.
Yeah. Now, people who are more substantial and they have, they do have a his and hers or whatever, but but most other people, it's just sort of, it's a mishmash, and
Right.
there you go. And
It's also possible over a course of time to convert your separate real estate assets to community assets by using community funds to pay mortgages, to make repairs. You put your community funds into a separate asset like that, and it's not like a bank account. It doesn't happen instantaneously, but over time it does taint that asset, and it becomes at least partially community property.
yeah. So one thing that I want to mention, you and I are probably more estate oriented, but the divorce area is a huge area related to this, and this is a big, there are big exercises in tracing and so forth, and trying to establish what's community and what's separate, and that may be effective in the divorce situation, and it doesn't apply so much usually in the estate situation. So I just want to caution people about that, and if you're concerned about it, you really should probably consult with the divorce attorney related to that, I think. Do you agree
Right.
with that?
Yeah, there are certain times that these the community versus separate party come up. Certain times, usually it's divorce,
Mhm.
death. Sometimes it comes up if creditors are trying to collect money from you, then the
Yeah.
difference makes it.
Including the IRS.
Yeah.
Okay. What about the tax basis issue? So tax basis is the cost that you use when you are determining gain or loss. How does community property versus joint tenancy relate to this basis?
Yeah, the basis situation, well, in income tax, it comes up a lot, as you know. It has to do with lots of things like depreciation, and those are things I'll let you discuss with people. But for an estate plan person like myself, basis is something that you are concerned with when a person dies, and property that's owned as joint tenancy property, which is a titling issue, doesn't necessarily get a full increased basis. So what I'm talking about is when a person dies under the present law, we've had some variations here over the last few years, but right now it's back to the point where you are allowed to increase the basis of the property when a person dies up to its fair market value.
Maybe the way to say it is it's a fresh start. So
Right.
there's some assets that may be adjusted down. So whatever the fair market value is at death, that's the cost that you're going to use on your
Right.
gain or loss schedule.
Right, so instead of what you paid for the property, it's the value of the date of death.
Yeah.
So you want to be able to do that, particularly if you're married, I would think, and you leave your property to your spouse. You'd want to be able to have the surviving spouse increase that basis as much as possible, assuming the property appreciated. These days we have to be careful. But if you own it as joint tenants, then that doesn't necessarily happen. So I think one of the reasons that we now have this new type of title, fairly new, community property with right of survivorship, is so that you get kind of the benefit of the community property ownership, which allows you to do that step up in basis and still have the right of survivorship element if that's how you want to transfer the property when you die. So, again, this is something people don't necessarily think about when they're titling their assets. Oftentimes, titling decisions are made at a title company, and you don't really even know what to say. They're asking you what you want to do, and so I think a lot of times it's done by default.
Yes.
And yet it can still have tax consequences, as you know from your practice, that you end up with a different result because of the way people took title to the property.
Yeah. So I would